Raisi paras 123 to 124. And those are in our skeleton at 24 to 25. The final proposition is that there is no general principle that when the court interprets a policy, it must always start from the presumption that the decision maker's interpretation and understanding of the policy framework is correct.
That's very precise. I mean, just the framework.
That's going to be the proposition.
Okay.
My Lord, the judge was wrong to say otherwise. He relied on Hopkins Homes.
Sorry?
He relied on Hopkins Homes.
Yes, indeed.
And I'll come to obviously go through the judgment, but just for the court's reference, that's in the judgment at 175 to 176. And we say that he was wrong is shown by, again, Hermati para 69, Mandelia para 31, and a short extract from De Smith, which I hope you've received.
Thank you.
Paras 5, 191 to 192. And again, that's our skeleton 31 to 32. So with that, could I ask the court to please have a look at some of those authorities? Could we start, please, with Hermati, which is 2021. It's in the authorities bundle 2, and it's tab 21.
Help me if you could give electronic page references.
So 801, I hope, my Lord, will take you to it.
801.
Yes, so when I give the references, I'm going to give you what you should have in your electronic bundle rather than the pagination internal to the report, if that's
Electronic
easiest.
bundles.
Yes.
Very helpful. Yes, thank you. Hermati.
My Lords, this is the most recent articulation of the Nadaraja principle, and I'm not going to take that case up right now. It's paragraph 68. We'll come and look at that later. This judgment not only articulates Nadaraja, but as I've said, it also makes clear that the court is the final arbiter of interpretation, and we also rely on it in support of the no Hopkins presumption. If we can just have a quick reminder of the facts and the outcome from the head note. There was detention pursuant to the discretionary power to detain, conferred by Schedule 2 to the Immigration Act 1971. You can see that, I hope, at letter F in the margin. The claimants sought to judicially review their detention on the ground that it breached a council regulation. And at first instance, and you can see this at letter G, 4 out of 5 claims were dismissed. Court of Appeal allowed those appeals, dismissed the Home Secretary's appeal. The Home Secretary appealed to the Supreme Court, but that appeal was also dismissed. And if we go over the page to page 802, you can see from letter D that one of the reasons the appeal was dismissed was on the basis that the Home Secretary's policy in relation to detention pending removal in Chapter 55 of the Enforcement Instructions and Guidance did not satisfy the requirements of law within the meaning of that regulation. And if I can ask you please to go to page 831.
Find where it says that. Does not have the necessary qualities of certainty and predictability to constitute a binding provision of general application so as to amount to law.
Yes. And if my Lord looks further up, you can see 3 lines above D.
Above D?
Yes. Did not establish objective criteria for the assessment of whether such a person might abscond. Contents did not constitute a framework of certain predetermined limits, and so on.
Yeah.
If we could go to page 831 in the judgment of Lord Kitchen, you can see at the bottom of the page the heading Domestic Law.
So Lord Kitchen was the lead judgment?
Yes, he gave the judgment on behalf of the Supreme Court, and my Lord will see that from the top of page 820.
Yes, everybody agreed with him.
So page 831, para 40, is where the description of domestic law starts, and we can see within that, on page 832, para 43, a description of the policy. So that's chapter 55, which we saw referenced in the head note. And then if we can just turn on to page 834 and paragraph 50, you can see there that Lord Kitchen says, and he accepts, that the executive must follow the stated policy unless there are good reasons, good grounds for...
Sorry, I'm not with you. Where are you reading?
Paragraph 50, my Lord.
50, yeah.
Page 834.
First sentence, yeah.
Yes, exactly.
Thank you.
So he said that, and then he goes on, and you see this over the next several pages. He analyses and interprets the chapter 55 that we saw of the policy. And that is the analysis that was in the head note as to whether or not it satisfied the criteria and requirements of the regulation.
Does the type of policy matter? I mean, this is a public-facing, published policy in
Yes.
this case, is it not?
Yes?
Yes. This was not in our case.
No, I'm going to show you an example. Mandelia is an example of a policy that was not published, and in my submission, for the propositions that I have given you, there is no difference. And in particular, I'm showing you this case, as I said.
So just to be clear, your submission is there is no difference, that even in terms of context, the court would not regard a policy of the kind we're dealing with here as different from a published public policy for the public at large, immigrants at large in this case, from something as very narrow as the RAVEC policy as a reference we're concerned with here. I'm just interested to know what you say. I mean,
My Lord,
naturally one might have thought that the court would anyway look at the context in which the policy was published, right?
yes, but in my respectful submission, the principle that the court is the final arbiter is not different. That is my point.
Oh no, as to the final arbiter of what it means.
Exactly
Yes,
so, my Lord.
absolutely.
Exactly so.
I'm
And
not sure that's in contention.
well, except for the Hopkins presumption point.
Okay, well we're going to come to
And we're going to come to that. And as I said, I'm showing you this in part. You will have appreciated that this is a few years after Hopkins Homes.
Yes.
Hopkins Homes was 2017, this is 2021. I'm showing you this in part to show you what the Supreme Court did when faced with a policy that had interpreted it, and I'm going to just show you a few other passages to make good my point that this doesn't support the Hopkins
Were
presumption.
they asked to consider Hopkins in this case?
No, interestingly they weren't. Nobody even cited it. But could I just return to my Lord's question? I don't want to not answer it fully. So, in terms of the proposition that the court is the final arbiter and that there's no Hopkins presumption, I do say that this is the same, whether it's outward-facing or internal. I will come on to look at what matters when you're interpreting as the final arbiters. And in my submission, it will be purpose, content, that is the text, and context. So, of course, when the court is actually engaging in that interpretive analysis, you do look, in my submission, at the context. And that can include outward-facing, internal-facing, and so on. So, my Lord, I was just going through this section, which starts now on page 835. It's the heading just above paragraph 52, to say that you can see from the pages that follow the interpretive exercise that the Supreme Court did. It goes all the way up to paragraph 74, but I wonder if we could just stop off and look at paragraph 69 first of all. Paragraph 69 is the one that I've identified to you as the basis for the propositions I've given you about Hermati. It is on page 100 and 840. If I could just ask you to read that before I make some points about it.
Is that the one that you referred to in relation to 3 or 4 of your propositions?
Yes, my Lord.
69. Let's
Yes.
read it.
Yes.
I mean, you can read it out. It always helps me if you read it out. I know that.
Certainly. I'm conscious that my Lords may get tired of hearing my voice,
Well,
but
except that it's only 10 lines, and it may be important for everybody else in court
Yes.
to hear what you're saying.
there can also be no doubt that in this jurisdiction, a policy statement such as Chapter 55 of the EIG has significant legal effects. I have referred to these at paras 50 to 51 above. In broad terms, and as Lord Justice Laws explained in Nadaraja, where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law requires that promise or practice to be honoured, unless there is good reason not to do so. Moreover, the court is the final arbiter of what a policy means. There's then a reference to Kambadzi and Mandelia, which we'll come on to look at. It is also well established that compliance with such a policy is enforceable by individuals before the courts. So, my Lords...
So you say that's very clear and comprehensive.
Clear and comprehensive in, first of all, setting out the Nadaraja principle, setting out the court as the final arbiter, but then it's a nil return, if you like, in terms of Hopkins. There's nothing there about a general presumption. And this would be the sort of case to say it, because it's an immigration case. And as we'll come on to see, the respondents say that planning and immigration are examples of where the presumption that they rely upon bites. So nothing here. And as I said in response to a question earlier, my Lords, it wasn't even cited in argument, let alone referred to by the court. The next authority is Mandelia, which is 2015, and it's Bundle 1, Tab 12, and electronically it should be page 475.
This is earlier, isn't it?
I'm so sorry, my Lord, I didn't.
Earlier.
Yes, this is 2015. And again, just as a reminder, I'm citing it for court being the final arbiter and also the no Hopkins. Again, if I could just take the facts from the head note on page 475, you can see from the top of that there was an applicant for a UK visa, and he failed to provide evidence of sufficient funds for the requisite period. You can see that between letters E and F. He only provided evidence for part of that period. And then we can see going down to G that there was a process instruction given to border agency caseworkers, which required that in certain circumstances they ask further questions from the applicant before determining the application, and no such request was made to the applicant. His application was refused. So pausing there, my Lord, this is an example of that internal-facing policy that I referred to earlier. If we go to page 478.
It was unpublished, the process instruction.
Yes.
Yeah, sorry, which page?
Page 478. This is the judgment of Lord Wilson for the Supreme Court. And you can see the question that the court was considering between letters B and C. The question is, did it act unlawfully in refusing his application without having first invited him to supply a further bank statement and so on?
Sorry, I'm not not with you where you are. Which paragraph?
It's the continuation of paragraph 1.
Oh, right.
And it's page 478 between letters
between B and C. Sorry,
Yes.
I thought you said D and E. Yep, got it. Thank you.
The relevant legal principles start at paragraph 29 on page 484. And you can see from the top of page 485, and again it's between B and C, that Lord Wilson refers to the applicant having the right to determination of his application in accordance with policy. Now generally taken to flow from a principle no doubt related to the doctrine of legitimate expectation but freestanding, which was best articulated by Lord Justice Laws in Nadaraja, and we there have set out that paragraph 68 from Nadaraja.
Yes.
And then the key paragraph that we rely on is 31, which is at the bottom of that page. And if you could have a look between letters G and H, please.
Yes.
Lord Wilson says that the Secretary of State does not say there were good reasons for not following the policy, but that properly interpreted the instruction did not require the caseworker to alert the applicant. And he then says that the search is for the proper interpretation of the process instruction. You see that at the bottom of the page. No more and no less, he says. Indeed, in that regard, it is now clear that its interpretation is a matter of law, which the court must therefore decide for itself. And over the page, previous suggestions that the court should adopt the Secretary of State's own interpretations of her immigration policies unless it is unreasonable, made, for example, in Gangadeen, are therefore inaccurate. And we say, again, my lords, that this paragraph shows that the respondent's reliance on Hopkins as creating a presumption of general applications is not a good one. And just so the court has the answer that was given to that question that we saw in paragraph 1, It is in paragraph 36 on page 487. And you can see that the conclusion reflects the fact that the Supreme Court interpreted the policy for itself and said that the process instruction obliged the caseworker first to have invited Mr. Mandelia to repair the deficit in his evidence. My Lords, this case illustrates the point that procedure may in itself provide a benefit, because the right to file more evidence in this case, in Mandelia, was part of the procedure, but it was also a benefit. And similarly, we say, in the present case before this court, that the need for an RMB assessment is part of RAVEC's procedure, but also a benefit. And that is relevant when we come on to look at the good reason part of the analysis.
Do you think it could be said against you that you're trying to put public law into a very inflexible series of boxes, which the judge at paragraph 178 and following declined to do in this case because of the context, and he made that criticism effectively of your submissions below. I mean, the cases you've shown us so far are all immigration cases with policies that apply to, even if not published, apply to hundreds of thousands of people, and a process in immigration does have to be fair. All processes have to be fair, but the processes don't necessarily have to be the same in every type of case, because fairness is not put into little self-contained boxes. And I'm just interested to know whether you would accept the criticism that so far you're adumbrating really quite inflexible, monochromatic rules that are applicable to everything called a policy. And we've, for the avoidance of doubt, looked very carefully at the underlying documents in this case. And the so-called policy is, in fact, called terms of reference.
Yes.
And is quite short and not the same, anyway, as many of the immigration policies many of us have had quite a good opportunity of looking at. What do you say about applying these sort of tightly drawn principles in this situation?
My Lord, I would not accept that criticism if it were to be made. And the reason for that is I don't accept the characterization that what I've described to you are tightly drawn boxes. What I've described are principles or propositions that guide the way the court should approach this particular case, involving, as it does, the interpretation of a policy. I entirely accept that each policy will be different, and what it requires in terms of the court's consideration will be different. And I am going to come on to look at what, on the facts of this case, I accept you should be looking at. Contrary to the characterization in the judgment, I am not pressing on you a mechanistic, literal interpretation. And the reason for that, and obviously I will come on to develop this, is I don't say that we get the meaning from the four corners of the document. I don't say that. That is why this isn't about boxes or tight adumbrations, which may be a straitjacket in a public law context. This is to say, and as my Lord said, it is accepted that the court is the final arbiter, subject to the difference on Hopkins. The question is how you go about that job. And in my submission, you don't defer to what RAVEC thinks the policy means or says, but that's one end of the spectrum that the respondents are pressing on you. I'm not going to the other extreme end of the spectrum to say, well, just look at the words on the page. Don't look any further. Look at it as if it was an act of Parliament or a contract, although, of course, even in those cases, one doesn't just look at the words on the page. I am going to be inviting you to take a much broader lens, to look at the purpose as well as the content. And when we come to look at the context, I will identify 4 strands that I say are relevant and engaged. And my Lord will see in due course that those 4 strands reflect the world that we're in of protective security provision, which is obviously different from planning or immigration. So, my Lord, I would not accept the criticism for those reasons.
Okay, thank you.
I want to move now to Raisi, which is 2008. And it is Bundle 1, Tab 6. It's page 224 of the electronic bundle. And you can see from the head note, letter G, that the claimant applied for compensation for detention under an ex gratia scheme, which was introduced in a ministerial statement to Parliament. Home Secretary refused his application. He applied for judicial review. And we can see, if we go over the page, please, a few lines above letter B, that the Divisional Court dismissed the claim on the basis that it was for the Home Secretary to decide the meaning and scope of his policy, provided that his interpretation was one which a reasonable minister could reach. And then you can see, if you have a look at a few lines above C, that the correct test in interpreting the ministerial policy statement was to ask what a reasonable and literate man's understanding of it would be, and not whether the meaning attributed by the minister to the words of the policy was a reasonable one. It was for the court to decide what the ex gratia scheme meant on the basis of what a reasonable and literate person would understand the circumstances to be. And could I just give you, for your note, that the statement is at paragraph 4 on page 231. And it makes clear that there was no underlying statutory provision in that case.
Yes.
And then if we can have a look at the 2 paragraphs which I've cited to you, paragraphs 123 and 124. They are on page 258. And in 123, you can see that the Court of Appeal say we shall use the ex parte web text, whilst accepting that it could be worded in a more modern way. That text that they have referred to is in paragraph 108, which is on page 254. And it's in the quotation at the bottom of that page. So if you could pick it up 3 lines from the bottom. The government has made funds available for the payment of compensation without being under a statutory duty to do so. It follows in my judgment that the court should not construe this scheme as if it were a statute, but as a public announcement of what the government was willing to do. This entails the court deciding what would be a reasonable and literate man's understanding of the circumstances in which he could, under the scheme, be paid compensation for personal injury. And then if we go back to page 258, you can see the questions that are posed there in paragraph 124. What does the scheme mean? What was its purpose and scope? Who is the minister intending to compensate? We've already set out its terms at para 4 above. The purpose of the scheme, as set out in para 1, was self-evidently to compensate those who had spent a period in custody resulting from a serious default on the part of a police officer. So that point, that is being made there, namely that the terms of the policy define its scope, because that's what the court is doing. It's interpreting who comes within the scope. We see that there, those who had spent a period in custody and so on. That is evident from the observations of Lord Steyn in the McFarlane case, which is set out earlier in the judgment on page 256. So if you go to 256 and have a look, please, at letter G, this is the quotation from Lord Steyn, who was dissenting in that case. He says, the decision maker, here a minister, may depart from the policy, but until he has done so, the citizen is entitled to ask in a court of law whether he fairly comes within the language of the publicly announced policy. That question, like all questions of interpretation, is one of law. Now, although he dissented in that case, this dicta has been followed by courts and accepted to be good law. And I just refer, in support of that, to my Lord Justice Bean in the Secretary of State for the Home Department in JB, which is 2022 EWCA Civ 1392 at para 56.
So is that not in the bundle?
No, my Lord, it's just...
Give us the reference again then.
Yes, of course, certainly. It's 2022
Yeah.
EWCA Civ 1392.
Yeah. Can it be provided to us electronically?
Yes, of course, and it's para 56. So that is Raisi, and could we then go to Hopkins Homes, which is 2017?
Sorry, just before you leave that, could you read the bottom to the end of 124? I think you were on page 258.
Thank you.
Well, my Lords, I've already addressed that point. The appellant is not pressing a legalistic interpretation on this court. I've already said I'm going to come back to purpose, content and context. Could we then go, please, to Hopkins Homes, Authorities Bundle 2, tab 16, and it's page 622, electronically. The respondent relies on this for paragraph 22, which is the uncontroversial proposition that a policy is not to be interpreted as a statute or a contract. I've already shown you language to that effect. But the respondent also relies, and I will show you this, on paragraph 25. And it is said that that establishes a general principle that, and I quote from their skeleton, the court should respect the expertise of specialist decision makers applying a policy and start at least from the presumption that they will have understood the policy framework correctly. That's para 12 of the respondent's skeleton. And the judge accepted this in the judgment at 175 to 176, and we say that is wrong, and this case is not authority for that proposition that the respondents rely on it for and that the judge accepted. The case involved a planning policy, again just taking the facts from the head note.
Isn't there an infinite spectrum of decision makers, running from a Home Office official making decisions about hundreds and thousands of immigrants who absolutely require to be able to follow closely the words of a clear policy in order to be fair to everyone, through planning inspectors who are decision makers of great expertise and with long experience in making planning decisions, to whom some deference is obviously, or some respect is obviously due, through to people who make decisions about a very small cohort of people and are no doubt expert in national security.
Yes.
I mean, they're not the same.
No, and it's no part of my case to try and say.
It's much more nuanced.
Absolutely, absolutely, and I'm at pains to emphasise.
So you're not saying Hopkins is wrong.
No, not at all. I'm saying that I'm saying that the way in which it is relied upon by the respondents is wrong, because Hopkins is about planning, and the presumption that Lord Carnworth identified that I'm going to show you is about planning, and it's about the specific context of that case. What the respondent says is, no, this isn't just about planning. You can pluck this out of Hopkins, the planning context, and you can plug it in to protective security. So you, the court, are being invited to accept that your starting point, that is the way it is put, your starting point is the presumption that they know their policy. And I say that is wrong in terms of being a general starting point which creates a presumption in every case. So it is the respondent's case that is not allowing for nuance here. They are the ones pressing upon you an absolute presumption. So, my lord, I don't say Hopkins is wrong. I say Hopkins is limited to what it decided. And that is why I say we didn't see it in Hermati, we didn't see it in Mandelia, and that's for the very good reason that they weren't planning cases.
But, I mean, the question of whether it's applicable, in other words, something similar is applicable, is a matter for the court in every case.
Yes, as part of context, absolutely. Yes, and also there is a more general question, and I've addressed you on this, and I will come to show you Carlyle, which is this general notion of deference or weight. And again, it's no part of my case that Ravek does not have expertise. I accepted that in my opening remarks. But, my lords, one of the key ironies about this case is that the respondent presses on you Ravek's expertise whilst ignoring the expertise of the RMB. And that is something which I will come back to, because all that we are saying is your own process says you have to defer to the expert specialist body that your documents explain the importance of.
Let me just say something that may help you to address your submissions effectively later. I shall want to understand why you say that in this case any determination by RMB would have actually affected the way in which Ravek dealt with the issues of the claimant, particularly in circumstances where he was doing what he was doing, because the RMB assessment, as I understand it,
Yes.
is obviously it's a very detailed threat assessment, risk assessment, detailed analysis of all sorts of aspects of what's going on in the world. But what I'm slightly concerned about at the moment is, again, putting it into discrete boxes and saying the RMB is relevant to what Ravek was considering about this claimant in these actually unique circumstances.
Yes, and my lords, I will come to deal with, I hope, precisely that point. I do say this, though, given the nature of the submissions, that will be in closed session.
No, well...
So I will come on to that, but it won't be today, is my point. It will be tomorrow.
Yeah, okay.
But I hope that when we go through the documents, I will try and flag, especially in terms of the documents that the court has and is able to see, the parts that will pertain to that.
Will be relevant.
Yes.
Yes. Well, that would be very helpful. Thank you.
I was just showing you Hopkins and the facts. The context is the planning permission applications, and we can see between letters F and G that in each case the inspector had to establish whether particular policies of the relevant development plans were considered not up to date under the National Planning Policy Framework, and if so, what the consequences for his decision should be. And then if we go over the page to page 623, you can see the finding between E and F. And if I read it out, it's 3 or 4 lines down from E. The court's role was not to be overstated, and courts should respect the expertise of the specialist planning inspectors and start with the presumption that they would have correctly understood the policy framework.
I'm sorry, where are you?
Between E and F, and it's maybe 623.
Yeah, thank you. Sorry.
And it's 3 or 4 lines up from F.
Yeah.
And the bit I read out was the court's role was not to be overstated, and courts should respect the expertise of the specialist planning inspectors.
Yes, I see.
And so that's essentially the bit that the respondent relies on. But if I can show you in the judgment, and this is the judgment of Lord Carnwath for the Supreme Court. And if we go, first of all, please, to page 633, and you can see, I hope, at the bottom of that page, law and policy. Paragraph 22 refers to the correct approach to the interpretation of a statutory development plan. That's TESCO. That's then set out over the next page, and page 634, para 24. He says, in the first place, it is important that the role of the court is not overstated.
Yes.
And then over the page again to paragraph 25. And this is really the core passage for the respondent. He refers to whether it's a development plan or a non-statutory statement such as the NPPF. They're statements of policy, not statutory texts, must be read in that light. Even where there are disputes over interpretation, they may well not be determinative. Furthermore, the courts should respect the expertise of the specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. That's obviously the bit that I read out from the respondent's skeleton argument that they rely on. And then you can see that he refers to the role and says it's in some way analogous to that of expert tribunals in respect of which the courts have cautioned against undue intervention, and there's a reference there to an immigration judgment. Para 26, recourse to the courts may sometimes be needed to resolve distinct issues of law or to ensure consistency of interpretation. Specialist judges of the planning court have an important role. And then at the end of that paragraph, you can see there that he draws a distinction between issues of interpretation of policy, appropriate for judicial analysis, and issues of judgment in the application of that policy, and not to elide the two. So as to those two paragraphs, we make 3 points. They're in our skeleton argument at 32, but if I can just summarise. Paragraph 26, as I've just shown you, demonstrates and identifies that critical distinction, we say, between the interpretation of a policy and its application, and the role of the court in respect of the former. And we say, secondly, that the analysis and conclusion that I've just shown you, throughout that section, starting from paragraph 22, is highly fact and context specific. It is about planning. Self-evidently, we would say. It is.
Of course, the case is about planning. Why isn't the proposition of general application that the courts should respect the expertise of the expert decision maker and start at least from the presumption that they will have understood their own policy framework correctly?
Because, my lord, that's abdicating, in my submission, your role as the arbiter of the interpretation of the policy. You are entitled, in my submission, to have regard to how the decision maker interprets the policy, but to suggest that that is the starting point, and indeed a presumption that has to be overcome by the other party to the litigation, is, in my submission, wrong. And we saw that in the earlier cases where they talked about this idea that you start with the fact that the decision maker has applied it correctly unless you can show it's not reasonable. So it's not to say that you don't look at their expertise or how they've understood it, but you don't start from the presumption that they are right. So it is putting...
You don't start from the presumption they're right as to the interpretation if it said they're wrong.
Yes.
Because that's for the court.
Yes.
But don't you start from, if not a presumption, a certain level of respect, depending on the nature of the decision maker,
Yes.
or the expertise of the decision maker?
Yes.
Yes.
Yes, I entirely agree with that.
Yes.
And the third point is we don't understand the respondents to say in this case that the interpretation of the terms of reference is something that requires expertise. We understand them to be making a more general point, which is about how it's understood or applied. So in terms of the interpretive exercise, it's not one that needs some specialist input. For example, if the wording was of a technical or difficult nature that could not be construed without some sort of specific expertise. The next authority is De Smith. And can I just check whether the court would be assisted with a hard copy of De Smith? No.
Not in my case.
My lords, this relates to Hopkins and that sixth presumption. And those two passages that I referred to, 5191 and 5192, they reflect, we say, the obvious fact that Hopkins addresses the specific context of planning. And it's the sentence at the very end of 512, namely, the extent to which their lordships' warnings against over-legalisation are relevant in the interpretation of other policy provisions will depend on context. But that is really the short point. The extent to which you can take Hopkins and apply it is contextual, and we say that context isn't here. But again, De Smith does not suggest that there is some kind of Hopkins presumption of general application and does not therefore support either the respondents or the judge's interpretation.
It's just the last sentence, isn't
It is just the last sentence, my lord.
Which is what I think you've been saying to us.
Yes, which is why it's edifying to find it reflected in De Smith.
I'm not an editor of this book.
I am not. I hasten to add, I am not.
Sometimes happens. That
I've never
some
been
mischance
accused of
the-
citing my own academic work. Not to my knowledge, anyway. My lords...
You can do it, but you just have to be a little self-effacing in doing
Yes.
so. Yeah.
Yes. Could I ask you, please, now to go to Munjaz?
Yes.
And this is authority for the second proposition I gave you regarding the standard of review, for good reason. It's bundle 1, tab 2, and it's page 18, and I'm asking you, please, to have a look at the Court of Appeal first. And we'll go to the appellate committee afterwards. If we can just, again, take the facts from the head note. Starting right at the top, guidance in the code issued by the Health Secretary under the Mental Health Act 1983 The subject matter was the use of seclusion for detained psychiatric patients. And we can see a summary of what the code included at letter F. And the facts of Mr. M's case are then set out. We can see that one of the points raised was that the hospital's seclusion procedure departed from the code in a number of ways. Can you just see that by letter G? And then the facts of S's case are over the page. And if I could ask you to keep going to page 20, paragraph 3. And we see there that notes the guidance relating to seclusion in the Code of Practice was statutory guidance. And then a little bit further down, just above H, hospitals should observe it unless they had a good reason for departing from it in relation to an individual patient or a group of patients. And then if we go to paragraph 5, which starts at the bottom of the page and goes over, you can see that in Mr. M's case, the Court of Appeal held that the seclusion under the hospital policy was unlawful because there were no good reasons for departing from the code. And then S's appeal is addressed after that. Could we go, please, into the judgment of Lady Justice Hale, as she then was? Could I ask you, please, to start on page 58, and it's paragraph 73. My Lords, will see the heading further up that page, that this paragraph is in the section addressing the status of the Code of Practice. And paragraph 73, the second and more difficult issue is the weight which those to whom the code is addressed must give to its contents. Code is prepared for the guidance of doctors and others. My Lords, the next bit is important. No statutory obligation in the 1983 Act to observe it or to give reasons for departing from it. Therefore, no express statutory obligation upon anyone other than social services. And she then refers to a different statute, which is Section 7 of the Local Authority Social Services Act 1970, under which social services do have an obligation to act under the general guidance given by the Secretary of State. And she refers to the judgment of Mr. Justice Sedley, as he then was in Rixon, where he held that this meant that local authorities could only depart from the Secretary of State's guidance with good reason. She then describes what the first instance judges in that case did. They proceeded on the basis that, having considered the code, a hospital was free not to follow it unless to do so would be Wednesbury perverse. Now, my Lords, that is the submission that the respondents are making before you in their respondent's notice. They are saying what was essentially found by those two first instance judges, that the standard is Wednesbury, not good reason. The paragraph continues, there is a considerable difference between this approach and the Rixon approach, in which the code should be followed unless there is a good reason to the contrary. And you can see that she makes 2 points in the following analysis. She says, first of all, the fact that it would be contrary to the purpose of the code if hospitals were free not to follow it without good reason. And she says, secondly, and this is near letter C, that where human rights are engaged, the arguments for according the code greater status are compelling. And then she says in paragraph 76 that the code should be observed by all hospitals unless they have a good reason for departing from it in relation to an individual patient. So the approach followed by the first instance judges, that is of Wednesbury being the appropriate standard, was rejected by the Court of Appeal. If we can then go to the appellate committee in Munjaz, which is same bundle tab 5, and it starts at page 151. Just invite you to see the outcome on page 152. And then note paragraph 2 in between letters C and E. Code did not have the binding force of legislation and was guidance rather than instruction, not mere advice, and should not be departed from without cogent reasons, which should be critically scrutinised by the court. And then the remainder is applying that on the facts of that case. My Lord, could I ask you to go to the speech of Lord Bingham, paragraph 20 on page 191. Now, you might recall that at the outset, when I was giving you my propositions, I cited Munjaz, paras 21 and 69. I want you to see 20, though, because it explains 21. And 20 is a summary of the parties' arguments. So you can see that it begins with the question, if then the code is issued under section 1181, what is its legal effect in relation to those to whom it is addressed? And then there are, first of all, the submissions of the trust. And you can see the trust saying it's guidance, it describes itself as guidance, difference between guidance and instruction, and that there is no statutory obligation to comply with it. You can see that at G. No express obligation was placed on the hospitals to follow the guidance. And then you see the arguments made by Mr. Munjaz. And he said that there were three things that were important. So first of all, the consultation which preceded the drawing up of the code. Secondly, the parliamentary sanction it received, because it was issued by the Health Secretary. And the third was the high importance of protecting detained mental patients. So those are the three factors that Mr. Munjaz relied on, and he said that they, and you can see this submission at the very end of the page, show that the code was intended to be very much more than advice which hospital authorities might choose to follow or not to follow. And then over the page we have paragraph 21, where Lord Bingham says that the code does not have the binding effect which a statutory provision or statutory instrument would have. It is what it purports to be, guidance, not instruction, but the matters relied on by Mr. Munjaz show that the guidance should be given great weight. Much more than mere advice, which an addressee is free to follow or not as it chooses, should be considered with great care, and from which it should only depart if it has cogent reasons. And then right at the end of that paragraph, in reviewing any challenge to a departure from the code, the court should scrutinise the reasons given by the hospital for departure with the intensity which the importance and sensitivity of the subject matter requires. And then can I just show you paragraph 69, Lord Hope. And that's page 207. And you can see there that he agrees with Lord Bingham, and the clearly, logically and convincing comes from this paragraph. But of course, as my lords will know, that is just the meaning of cogent anyway. So all he's doing is unpacking the components of the word cogent, the clear, the logical, and the convincing. And then he goes on to refer to Parliament's expectation that the code would be followed unless there are cogent reasons for not doing so. But just pausing there, my lords, and just taking stock of what those two paragraphs show us, in our submission, what they show is that the analytical search that this court is also embarking on in this case is for factors that show that the policy in question is intended to be more than advisory. And where that line is crossed, where the court concludes that this is something that is more than advice, that is where the need for cogent reasons and judicial scrutiny is engaged. Now, going back to nuance and the importance of nuance, and as I've said several times, I entirely accept that the intensity of the scrutiny, it may be more or less intense, depending on the subject matter. But the critical point is, you do need the cogent reasons. And Lord Hope's reference that I've just shown you to Parliament, that in our submission is not restricting the statement of principle to cases where Parliament has such an expectation. That is the factual basis in that case for finding that the policy was intended to be more than advice. So it was one of the factors in the analytical search. It is not a requirement. And so we say that it's clear from Munjaz that the standard of review is of cogent reason. And just two final points on Munjaz. The difference in approach between good reason and Wednesbury that is identified by both the Court of Appeal and the Appellate Committee, we say, is important. And the reason for that is in Nadaraja itself. And I just want to now show you, I said I would show you a bit of Nadaraja. I want to show you why I say that difference is important. If we could go to tab 1, this is in bundle 1. It starts, bundle 1, tab 3, starts at page 65, and could I ask you please to have a look at paragraph 68, which is on page 97. My Lords will see at the start of paragraph 68 the proposition which I've already given you, and we've seen it in Hermati. But it's the bit which begins, what is the principle behind this proposition, that I want you just to look at, please. It is not far to seek. It is said to be grounded in fairness, and no doubt in general terms that is so. I would prefer to express it rather more broadly as a requirement of good administration, by which public bodies ought to deal straightforwardly and consistently with the public. In my judgment, this is a legal standard which, although not found in terms in the ECHR, takes its place alongside such rights as fair trial and no punishment without law. He then goes on to say that there is every reason to articulate the limits of this requirement, and he says a public body's promise or practice as to future conduct may only be denied, and thus the standard I have expressed may only be departed from in circumstances where to do so is the public body's legal duty, or is otherwise, to use a now familiar vocabulary, a proportionate response. And then at the end of that paragraph, the principle that good administration requires public authorities to be held to their promises would be undermined if the law did not insist that any failure or refusal to comply is objectively justified as a proportionate measure in the circumstances. So that was the first point in terms of explaining why that difference in approach is important and principled. And the second is that these passages that I've just shown you show why the respondent's notice and the related submissions are unmeritorious. And in their skeleton, at paragraph 14, the respondent says that the appellant, and indeed the judge, are elevating a fact-sensitive decision into a general principle. We submit that is an impossible reading of the passages that you've just been shown. It's obviously right that good reasons is a fact-sensitive analysis. You saw that from paragraphs 20 and 21 of Lord Bingham's speech, and that's a point that we expressly rely on. It's in our skeleton, for example, at 36.3. But the fact that the application of good reason is fact sensitive does not mean that we are in the territory of rationality. And the same paragraph in the respondent's skeleton argument also says, oh well, Munjaz is concerned with a policy under a statute, and so it's different. But again, there is nothing in the paragraphs that I have shown you that suggests that the point of principle is limited to where the policy has that statutory imprimatur. And that is no doubt because there is no coherent reason, we submit, to limit the principle in that way, especially when one recalls the underlying point that I've just shown you in Nadaraja. It would be absurd to suggest that the requirement of good administration is engaged only in cases of statutory guidance. So Munjaz is obviously the key authority since it's Supreme Court, but can I also show you briefly Tower Hamlets, which is 2013, and this is again on standard of review being good reason, but it's also authority for the proposition that the greater the departure from the policy, the more compelling the reason must be. It's Bundle 1, Tab 10, page 419. And this is a policy under the statute that I showed you in Lady Justice Hale's judgment in Munjaz. You recall she referred to Section 7 of the 1970 statute when she was talking about statutory obligations. And so that is the provision which this case is concerned with. You can see that on page 419 between letters F and G. And if you go over the page to 420, between C and D, you can see that it was a judicial review claim. It was said that the local authorities' policies were unlawful. And part of the local authorities' response was that if the policies were contrary to the statutory guidance, then there were cogent reasons for departing from it. That's just above letter E. And then at the bottom of the page at letter J, you can see that the court found that the local authority had not discharged the burden of showing sufficiently cogent reasons. And then if we turn on to page 429, if you look at paragraph 27 under the heading Status of the Guidance, you'll see that Mr. Justice Mayles, as he then was, he describes the legal status of that guidance. Under 1970, refers again to Rickson, and then he refers to Munjaz, and he says that although Munjaz addressed a different statute, what was said by Lord Bingham and Lord Hale applies equally to guidance issued under the 1970 Act. Now, I'm showing you that because it's an important passage in responding to the point that's made by the respondent, oh, well, you can't get anything from these two cases because they're statutory guidance cases. What we see here is the observation that the statutes were different. And the distinction is, as we saw again in Munjaz, that the guidance did not expressly oblige the hospital to comply, where the statute did not require the hospital to comply with the guidance. And the guidance under the 1970 Act is distinct because it did. And the point is, again, that that wasn't something that changed the approach. It was one of the factors that went into that analytical search that I say the court is embarked upon in those cases and indeed in this case. And so if I could then ask you to look at the key paragraph, which is 35 on page 430, you will see that he says there, departure from the guidance will be unlawful unless there's a cogent reason for it. And the greater the departure, the more compelling must that reason be. The next case is HZ, which is Bundle 2, tab 28 and page 1047. So this involved, we can see from the head note, a challenge to the defendant's decision to offer two claimants temporary accommodation in Manchester rather than London. You can see the grounds of challenge from page 6 on, paragraph 6 on page 1051. And one of them, you'll see in little Roman 2, was that the defendant had failed to follow policy. And if we turn on, the relevant principles start at paragraph 104 on page 1084. And it is in that section that we find the passage that we rely on, which is on page 1086, para 107. And it's that last sentence in particular. Certainty with which a policy is expressed may be relevant to the questions of whether the defendant has in fact departed from it, and if so, whether or not there was good reason to do so. Now, my lords, that's cited by the respondents as well. It's in their skeleton at paragraph 13. And they cite it in support of the assertion that the context, nature and terms of the policy will affect what needs to be shown by good reason. They then later in their skeleton at paragraph 26 make a submission where they say, and I quote, where there is no dispute that D is entitled in law to depart from the terms of reference, and it goes on, it is impossible to understand the assertion, they say in our skeleton at para 34, that there was a legal error in the judge accepting that D had a discretion to depart from the terms of reference. Now, I will deal later with interpretation, but can I just make 2 points on that submission in the respondent skeleton now? First of all, the appellant submits that the judge erred in his construction or interpretation of the terms of reference insofar as he held that the terms of reference themselves or itself gives RAVEC the discretion. We say that is an error of interpretation, because properly interpreted, when you look at that document, it does not contain, even when put into context, that discretion. But second, it is of course common ground that RAVEC is entitled in law, in general, to depart from the terms of reference. But the reason why that interpretive exercise matters is, as I've said, the terms of the policy are going to influence what is to be regarded as a good reason. Because as we've seen in both Tower Hamlets and now in H said, that the certainty with which the policy is expressed is relevant to whether or not there's a good reason for the departure. And as we saw in Tower Hamlets, the greater the departure, the greater the need for there to be reasoning explaining it. So it's not good enough just to say, well, we all agree that you can depart from a policy, so why do we need to spend all this time looking at what the policy means? Why can't we just go straight to whether or not there was a good reason? The reason is that analysis of whether or not there is cogent reasoning supporting the departure has got to be assessed by reference to the certainty of the policy and what it says and what it means. Begum is the next one, and my lords, this relates to the second proposition in the sense that it is relied on by the respondent in support of the proposition that the standard of review is Wednesbury. And we submit that the respondent's reliance is based on a complete misreading of the judgment. Since it is one of the respondent's cases, other than flag for you that we have made our points on Begum in the skeleton at paragraphs 53 to 62, I'm not going to turn to it in opening. I will deal with it in reply if I have to. The court has our submissions in those passages. And so the last authority to show you is Carlisle. and this is about weight or deference. It's Authorities Bundle 1, tab 13, page 488. And of course, the facts are very far removed from the present case. It's relevant, though, because it addresses the role of the court when considering the proportionality of executive decisions. Now, this was in the Human Rights Act context, but there is, of course, some overlap. And as we've seen, proportionality is part of the court's analysis when it considers whether there is a good reason to depart. You recall I showed you that passage from paragraph 68 of Nadaraja making that point. So this is relevant for those reasons. And if I just invite you to look at the head note on page 488, although proportionality was ultimately a matter for the court, that did not entitle it to substitute its own decision for that of the primary decision maker, or simply to frank the decision without itself considering it. But the degree of restraint to be exercised by the court and the extent to which the assessment of the primary decision maker would be respected depended on the context. And then it goes on to... I should just read the next bit as well. Where the decision was based on factors where the court did not have the evidence, experience and institutional legitimacy to form its own view with confidence, its interference could only be justified in exceptional circumstances. The reason I just wanted to read that out is I will be saying to you that you do have evidence in this case. That is one of the relevant points. And then just show you paragraph 22 in Lord Sumption's judgment, which is on page 508. And it's the bit around letter B. In some circumstances, deference is no more than a recognition that a court of review does not usurp the function of the decision maker, even when convention rights are engaged. Beyond that elementary principle, the assignment of weight to the decision maker's judgment has nothing to do with deference in the ordinary sense of the term. It has two distinct sources. The first is the constitutional principle of the separation of powers, and the second is no more than a pragmatic view about the evidential value of certain judgments of the executive, whose force will vary according to the subject matter. He then refers to Lord Hoffman's speech in Rahman and quotes from it. And if we go over the page, page 509, and it's paragraph 54 of the quotation, you can see there that Lord Hoffman says it does not mean that the whole decision on whether deportation would be in the interests of national security is surrendered. And then 4 or 5 lines down, the factual basis for the executive's opinion that deportation would be in the interests of national security must be established by evidence. Again, that is something that I will be coming back to, because what you have in this case is Ravek's opinion that the bespoke process is better than the RMB. And that is obviously something that you're going to be looking at to see whether or not the reasoning given is clear, logical and convincing. And one of the ways in my submission that you're going to want to do that is by looking at their own evidence, which you're perfectly entitled to do, as these cases show. And then just one more quotation from Lord Hoffman, which is on the evidential issue, and it is also, I think, at paragraph 24. I've just lost my note. Just give me one moment. Actually, my lords, I don't think I need to show you that, so I'm going to move on. And I want to just end the legal section with this. The fact-sensitive approach that we've seen in a number of these cases is consistent with the approach regularly taken by courts when they have looked at the facts and they have rejected a attempts by the government to invoke some absolutist deference principle in contexts where the court is the ultimate arbiter. And there are two examples in the bundle, which I may come back to in reply, but I just invite you to note them for now. The first one is Rwanda in the Supreme Court, and that's Authorities Bundle 2, tab 27, page 999. And the question in that case, as my lords may recall, was whether there was a real risk of reform on, which was a matter, just like whether there's a good reason to depart from a policy, for the court to assess. And I just invite you to note paras 51 to 52 of the Supreme Court's judgment, which is page 1019. In essence, the court was required to make its own assessment, attaching appropriate weight to the government's view, and then also paras 55, 6 and 7. And then the other illustration you have is the Attorney General and BBC case, which is Authorities 2, tab 25, page 969, and it's paragraph 29 that's relevant there. As I say, I may come back to those in reply, but they make the point, which
Can you give me that reference again?
AG in BBC, it's paragraph 29, it's Authorities 2, tab 25, page 969. So they make the point that is already made by Carlyle about the extent of the weight or deference that may be appropriate, and not to assume that it has the sort of general application that the government often claims that it does have. My Lords, on the respondent's notice, I've already addressed the case law at some length, but can I just make three short concluding submissions on it? First of all, Munjaz is obviously binding on this court, and we say that it makes it very clear that the test is not Wednesbury rationality. The second point is that the respondent has not identified a single authority which supports its position, and the judge noted that in the judgment at para 157, and I've already addressed their purported reliance on Begum, which they're misreading. And then the third and final point is, as I have said throughout showing you the cases, that the invocation of constitutional principle and concerns about democratic accountability in particular are not engaged here. The respondent's position appears to be that whenever there's a discretion, and if convention rights are not engaged directly, then you're in the territory of rationality because of the principles of democratic accountability and institutional expertise. And they say in their skeleton at para 15, and I quote, "Any other approach would require the court to substitute its own judgment on the merits for that of the constitutionally accountable and institutionally competent decision maker." And we say that's a very, very far-reaching submission, and one that sits uncomfortably with the fact that there are many contexts where this court will be required to consider whether the executive has satisfied a particular standard on a more hard-edged basis than rationality. Obviously, good reason is one, legitimate expectation is another. That doesn't mean, as I have now said a few times, that consideration and appropriate respect won't be given to the expertise of the decision maker. But the good reason threshold has still got to be looked at on the facts to see whether or not cogent reasons have been given. And we say that that provides an answer to the respondent's submission that a rationality standard is required because it has built into it the ability to take into account a spectrum of contexts. That is what they say in their skeleton at paragraph 15. That's not a good explanation because obviously good reason has exactly the same sort of fact-sensitive spectrum built into it. And then they say finally at paragraph 16, well, we all understand what a rationality review entails, so we should apply it for that reason. And we say, well, we know what the cogency test involves. I've just shown you that. That is also clear and well established. And the problem, and in our submission, the reason why the Wednesbury review test is being pressed on you is because the respondents cannot satisfy good reason. They cannot satisfy cogency, and that is why they are submitting that the Wednesbury test is the one that's applicable. Now, with that, can I turn, somewhat later than I had hoped, to ground 1A and interpretation? Now, can I give you the key paragraphs in the judgment that I'm going to be addressing? 158, 159, 162.
Sorry, I wasn't ready for that. 158.
159,
Yeah.
162, 175 and 176. Those are the key paragraphs. Now, in terms of the structure of my submissions, what I want to do is just introduce the key documents, and I may be able to take this quickly if the court is familiar with them. I just want to make sure that you have seen the parts that I want to show you. And then I'm going to flag, as I've been saying, the purpose, content and context that we say the court should be looking at when doing that interpretation exercise. And I then want to make submissions on what we say are 3 interpretive errors that were made by the judge. In terms of the documents, if I can start there, obviously the court will have the fact that the most important document in this case is the 2017 terms of reference. That was in place when the February 2020 decision was made. And Sir Richard Mottram says that the 2017 version, although less detailed than the 2021 version, does not differ in any significant way in terms of the role of RAVEC and its approach to its remit. That's Mottram 1, para 10, supplementary bundle, tab 2, page 37. And
as an electronic reference for that. I mean, if you can give me electronic
I think it
reference.
is. I think it's 37. So the page number I give you should always be the electronic reference.
In the supplemental or core?
Supplemental, and it's tab 2.
37.
Supplemental, page 37.
Okay, thank you.
And my lords know that RAVEC has made decisions about the appellant since 2021, and so we submit that although the focus of your analysis is obviously on the 2017 terms of reference, the 2021 terms of reference are plainly relevant in informing your analysis regarding the decision-making process. Both of the terms of reference...
I thought we were only concerned with the decision of the 28th of February 2020.
My lord, that's correct, but I think it's accepted on both sides that if that's unlawful, then that's going to influence the decisions that were subsequently taken as well. So I don't understand that any point is taken by the respondents as to the fact that there were different terms of reference in play from 2021 onwards.
I don't see, speaking for myself, how the later terms of reference can help us as to whether the 28th of February 2020 decision was lawful or not.
Well, my lord, it helps in my submission because you're looking at RAVEC's process.
Looking
That
at RAVEC's what?
RAVEC's process.
Process.
Yes, it's the decision-making process.
Yes.
That process is in the 2017 terms of reference. I'm going to give you references to that document. All I'm saying is the 2021 document is relevant, and Sir Richard himself has said that there isn't a significant difference. And the only reason I'm asking you to even look at the 2021 document is it has more detail, and that detail is helpful in understanding that process. And although there are some things that are different, for example, in 2017 it was the chair that took the decisions, in 2021 it's the committee.
Yeah.
As far as I am aware, there is no material significance in terms of the role of the RMB, and that is obviously the critical issue for us on this appeal. And that is the reference I've given you to Sir Richard's first statement at paragraph 10. So I'm inviting you to look at 2021 to fill in some of the colour that we don't have from 2017. Both of the terms of reference are written or reviewed by RAVEC on an annual basis. And my lords, if it's convenient, could I just give you the references without asking you to turn them up? And if it's convenient, I will give them, first of all, to the 2017 terms of reference and then to 2021, just so you know the order. So that's paragraph 24 of 2017 and paragraph 45 of 2021. So those are the two terms of reference documents. There is also a document which has been referred to as the EC, or the evaluation criteria. That is also a 2021 document. The judge said that caution is needed in using this to determine if the 2020 decision is unlawful. That's in the judgment at para 163. But again, there has been no suggestion from RAVEC that the EC contain any different approach vis-à-vis the matters with which this claim is concerned, namely the role and significance of the RMB and of the RMB's assessment in RAVEC's decision-making process. Now, those EC documents, as I will call them, they are required by and referred to in the 2021 terms of reference. And you'll see that in para 6, bullet point 7. So the document, the EC, it's part of RAVEC's policy framework, and Mr. Hipgrave has said that the EC is intended to ensure decisions are taken in a consistent and transparent manner, and that RAVEC has employed it. That is the EC. So again, anticipating what my lord may ask me in terms of its relevance, it has the same role in my submission, which is to provide some colour for when you're looking at RAVEC's process in 2017, certainly, because that is the relevant document for the 2020 decision. But as I say, I do not understand it to be said that the RMB's role or the role of its assessment changed between 2020 and 2021. And if that is a point taken against me, then I will reply to it. I am not aware of that being a point. Now, the court may have seen that when this claim started in 2021, the only terms of reference that the appellant was aware of is the one from 2008. I just want to make sure that you've seen that. It is in the bundle, supplementary 10, page 167.
Very short.
It's very short. Precisely so, my lord. And that is significant. One sees the evolution of the document in the intervening almost decade. And we know why the document evolved, because we know that there were two reports that were produced for RAVEC, the TESH review and a report by the College of Policing, and we see the significance of their input into the terms of reference. Why does that matter? It matters because it shows that this is not a merely advisory document. It is far greater significance than that, because you can see that RAVEC itself was, in my submission, taking on board the views of undoubtedly experts to inform what it was doing. And we will say in due course that that is similar to the consultation that you saw in Munjaz, which led to the code. The consideration of the content in a careful way. Now, I want to go through each of purpose, content, and context. I hope I can do the first two quickly, because it's just by reference to the documents themselves. The purpose of the terms of reference is to set out who RAVEC is, what it does, and the process that it follows to make decisions. And we see that from para 6 and para 20 of the 2017 document, and paras 2, 6, and 7 of the 21 document. And in terms,
I find that very helpful without going to the document.
my lords, I'm very happy to take you to that. What I was going to suggest, but I see that my Lord Master of the Rolls is working only electronically. The most helpful thing to do is to have them both side by side, which you're not going to be able to do. There's a little bit of flicking backwards and forwards otherwise. I don't.
Just explain why the 21 makes any difference. I mean, perhaps naively, I thought that you relied on the sort of mandatory nature of the requirements for A and B.
Yes. That
Which is actually the same.
It's exactly the same, precisely so. Why do I rely on the 2021? It's because of the EC.
Yeah.
That document is part of
Yep.
the 2021 terms of reference.
Yep.
Why do I rely on the EC? The EC tells us why we need the RMB. You don't get that purely from the face of the 2017 terms of reference in the same way. You get some information.
Can we look at it?
The evaluation criteria, my lord.
Yes.
Yes, of course. It's page 173.
Which paragraph?
Well, there are a number of paragraphs that I want to show you about this, but perhaps the most critical, if you go to paragraph 5 on page 174, the 2016 TESH review is currently the key document underpinning the principle that RAVEC should make decisions based on an evaluation of the risk analysis conducted by the RMB. TESH differentiates between analysis and evaluation in the following way. And you can see there's a quotation from paragraph 16 of the TESH review. And what John Tesh said is that the best risk management processes encompass but make clear a distinction between, and then you'll see that there are two things. So first of all, you have risk analysis, and the next paragraph, you have risk evaluation. Now, risk analysis is described as an objective, dispassionate inventory of what the risks are, including what would have to be reckoned with in terms of the impact and what the associated likelihood is. Now, pausing there, that's what the RMB does. We then see risk evaluation. That's a policy-making process in which social values and risk tolerance levels are factored in by ministers and officials in order to decide about the objectives of policy, what measures can or must be taken to achieve those objectives, and whether the residual risk is tolerable. That is what RAVEC does.
Yeah.
And then if you, since we're in this, perhaps I should just show you a few more of the passages. You can see in paragraph 8, well, standing back, I should say, what they're doing in 6, 7, and 8 is explaining, essentially, that they need to develop the risk evaluation framework. So the bit that RAVEC does, they're trying to develop in this document, not the bit that the RMB does. And they're explaining in paragraph 8 why that framework would help. So you can see, to ensure that decision-making processes are applied consistently across the cohort of protected principles, ensuring that different factors are not weighted disproportionately in relation to different principles. It will also strengthen the transparency. And then you have the heading criteria for evaluation, where they then go on to explore that very thing. And you can see that they say, worth exploring each of the criteria for evaluation set out in TESH. And my lords, this sentence, which understandably I put great emphasis on, the description of the RMB, crucial to that consideration, that is, of what should be in the criteria for evaluation, crucial to that consideration is the parallel review of the RMB.
When did that take place?
When did...
The review. You referred to TESH.
Yes.
And it was 2016?
It was 2016. I don't believe that we know the date of the RMB review. You can see that it's described in some more detail later on in that paragraph. I'm obviously not going to continue reading out. But you'll see.
What I was puzzled by is paragraph 8, which says developing such a framework, obviously in the future, should also help assure committee members that decision-making processes are applied consistently, etc.
Yes.
So, I mean, this is all forward-looking, is it not?
Yes, it is, as far as risk evaluation is concerned.
Yeah.
But we're not. But my lords, I'm not troubled by that, because I'm not asking you to look at how RAVEC itself has evaluated the protective security. That is not part of my challenge. My challenge is the process that RAVEC followed before that. Because what you see in the terms of reference is that RAVEC's risk evaluation has got to be based on the RMB's risk analysis. It's got to be based on it. They're not done side by side. One is not done as an advisory, oh, well, if you want to ask the RMB, then by all means do. No. It is a principle, that's how they describe it themselves, that came from the TESH review. And that's why when the judge criticised my referring to the words in the document, the will, we'll see that in the key tasks, the executive committee will, and then refer to getting the report from the RMB. It's not just a fixation on the language, it's because we have a rationale. And the rationale is not just that the RMB is a distinct body with distinct expertise, but it's doing something different. And that's why I say this document matters, because it supplies us with the rationale.
It analyses and supplies detail as to the risk in broad terms. So without them, you don't know what the level and nature and a lot of other things about the risk. Correct?
Yes, the objective, dispassionate inventory.
What I think will be said against you is that the decision RAVEC was making in this case was what was the consequence of the claimant stepping back from royal duties and going to live primarily abroad, as regards further protection being provided by Her Majesty's government for him when he came to England, and that is not affected on one analysis, I think it's said, by the absolute level of risk or the nature of the risk, because what they say, as I understand it, is there was put in place a process that whenever he announced his intention to come to the UK, some evaluation would be made of what for and where and why and how, and then risk might be relevant, but this was a decision as to the principle of whether, I'm going to use the wrong language, but blanket security should be provided when he was overseas under the RAVEC process.
Yes, that point.
And therefore it said, well, we're confusing apples and pears. The level of the risk is obviously critical when you come to consider what kind of security you're going to provide and the type of risk and so on. But this wasn't the question they were deciding. They were simply deciding whether he was within their cohort, and that's something for them.
It's not for them,
right,
in my submission. The terms of reference, and we've slightly digressed away from the structure that I was following, but the terms of reference, the reason why it's so important to look at them is they identify who is in the cohort. And can I just say, the word cohort is really apt to mislead.
It's apt to mislead, but I won't use it again.
Well, I say that, my lord, because if you look at the submissions and the evidence, it is used a lot. But it is not always clear what it means by the person who's using it. So I'm going to try and be more precise and not use that word cohort. Well, I'm going to say who is within RAVEC's remit.
Right.
Okay, that's the first question, and the answer is members of royalty and public figures. and I said this to Mr. Justice Lane, I am not within RAVEC's remit. Clearly. It's got to be someone who comes within that description. And we have evidence, and I will take you to it in the closed session, about what that means. So that's how you get... That's not about you. It's not controversial to say that the claimant is within the remit of RAVEC, is it? Well, it shouldn't be.
Stepping back from world use.
Well, precisely so. That's my point, my lord.
Well, they say that it's within their remit because they say they're going to consider what they should do whenever it comes to the UK.
Exactly. This is not a case where the appellant has been knocking on their door saying, let me in. They have let him in. So that is the remit question. Once you're in their remit, the terms of reference say that there are two questions for RAVEC.
Yes.
One is whether that person gets protective security. So being in the remit doesn't mean that you get it. They still will consider whether or not you should.
Yes.
And then they will consider, if you're going to get it, what you should get. So all of that has got to be considered. Now, going back to my Lord's point about the point that will be taken against me, so Richard's evidence is that when there was the change of role from full-time working member to not being a full-time working member,
yes,
his evidence is, well, the terms of reference don't apply to the appellant. We don't have to make our decisions under the terms of reference. And that's paragraph 14 of Mottram 1. Now, that in my submission is wrong. You cannot do that as RAVEC. He is obviously within your remit. He is a member of the royal family. You have accepted that he is within your remit because you are considering his case.
Give me the page reference for SRM. I'm calling him SRM 1, paragraph 14.
If you can give me one moment, because I've
Supplemental bundle, page 38.
stepped away. Thank you very much.
This is a non-confidential paragraph, is it?
Yes, it is, and it is. Perhaps if I can just show you from the top of that page, he describes the essence of implementing the policy. That's the government's national risk assessment policy. And then he explains that there are two guiding principles. You see what they are.
Sorry, I'm not seeing two guiding principles.
So
Paragraph.
this is paragraph 14, but it continues on page 39. I thought...
Sorry, I'm in the wrong place. I was confusing pages for paragraph.
not at all, my lord. So it's page 39.
Yeah, got it.
And he says at the top of that page, he refers, you can see, to the government's national risk assessment. And he says the essence of implementing this policy in the area of protective security was that, and then there's the first guiding principle, which is essentially where risk is sufficiently significant in terms of likelihood and impact on the interests of the state. And secondly, proportionate protective security measures should be provided at public expense appropriately to mitigate that risk. He then says, within these guiding principles, it was for RAVEC to determine which individuals were within the cohort, and you see what I mean about the use of that word, for which it took responsibility for the provision of proportionate security measures. And this cohort changed over time as the roles of individuals changed and as security threats evolved. Just pause
in
it.
that sentence, cohort means the people who satisfy 1 and 2.
Exactly.
Yes.
Exactly.
Right.
But sometimes it's not used in that way.
No, well, it is here.
Yes, and this is part of the problem. But anyway, moving on, he says, it follows that RAVEC did not produce nor was governed by a form of overarching guiding policy document which sets out who is to form the cohort and in what circumstances. There was no such document. Now, I accept that, of course. But what that means is when RAVEC's considering the whether and the what, the evaluation bit that we saw, there isn't something which explains in detail how it's going to do that. We have the guidance in the evaluation criteria, but we don't have a document setting it out chapter and verse.
Right.
And then he goes on. I and the members of RAVEC followed the guiding principles as set out above and reached decisions in individual cases in a flexible and context-sensitive manner accordingly, including by reference to how potentially analogous cases had been handled in the past. And this is the important bit, my lord. When the claimant refers to RAVEC's policy, it must be understood in this light. In particular, I should note that the 2017 terms of reference do not specifically address the responsibilities of RAVEC in relation to an individual whose status has changed and no longer falls within the cohort of principles. That is clearly a matter for RAVEC, but it is not a matter guided by the 2017 terms of reference. So what he's saying...
So do you disagree with that?
I say that's wrong.
Wrong in what sense?
That's not what the terms of reference say, and it's not what, in my submission, properly interpreted the terms of reference mean. What they mean, as I've said, is if you're within the remit, RAVEC has got to comply with those terms of reference. I mean, the name of the document is a clue. It's terms of reference for RAVEC. It's explaining how RAVEC needs to approach its decision-making. It is not saying...
Well, just pause for a moment. I completely see the sort of blanket nature of the submission that, terms of reference are terms of reference, and therefore what you do are guided by terms of reference. That's all very logical, if I may say so. But I think the problem here is this has never happened before. So there's not a part of the terms of reference which say what does RAVEC do when a previously active member of the royal family undertaking state duties decides to step back and go and live abroad. There's not a section that says...
No, there is not.
What I understand Sir Richard to be saying here, and I may be wrong, is that actually there's no specific part of RAVEC that addresses the responsibilities of status change, etc. So we were flying free in reaching a decision as to what to do. I think he's not saying we completely ignored terms of reference. He's just saying we didn't get specific guidance.
Well, my lord, I may be corrected by the respondent, but my common ground, you recall I began with this.
Yes.
As far as I understand it, it is common ground
Yes.
that Sir Richard did not consider that the 2017 terms of reference applied to the claimant. So...
Well, I think that's too broad a statement, isn't it? I mean, of course they applied to the claimant because they applied to everything the RAVEC did. What he's saying is what he's saying is precisely in this sentence. In particular, I should note that the terms of reference do not specifically address the responsibilities of RAVEC in relation to an individual whose status has changed and no longer falls within the cohort of principles. Now, I understand, but he's used that term here to mean people who are going to have protection.
Yes.
So let's assume he still means
Yes.
that. And that's clearly a matter for RAVEC, but it's not a matter guided by the terms of reference. So that's what he means. He's not saying the terms of reference don't apply to the claimant, or he doesn't have to apply the terms of reference, or even that he didn't consider the terms of reference. He's just saying, in this particular decision, I don't get any specific help from the terms of reference, isn't it?
Well, my lord, I haven't understood the respondent to be interpreting it in that way.
Okay. Well,
But as I say, I may be corrected in that.
Well, I should be corrected if I'm wrong as well. Yes.
My lord, it would make things a lot easier if what my lord is saying was actually the position. Part of the reason I'm having to fight this is because of the way it's been defended, which is to say, we didn't apply this at all. You completely fell outside of the process. But can I just deal with this idea of flying free? And I will come back to it in the closed session. RAVEC were not flying free.
No, of course not.
They
It's
were
a
not.
very bad expression.
No, it's very helpful, if I may say so, as a shorthand for this idea that essentially there wasn't a precedent. They were not flying free. And that's why this whole structure of how they approached it, what they were thinking about, how they explained themselves, we'll come on to the contemporaneous document, it matters. And so, my lord, going back to this point that you made to me about it will be said against you, well, this is all very interesting, but this was novel and unique and different.
Yeah.
In my submission, no. That there are guiding principles in these documents and in the practice of RAVEC that show, as I said, that the bespoke is in fact different, unjustified and inferior. And we need to get into the detail.
The bespoke is what?
Different, unjustified and inferior.
Oh, I see. You mean this bespoke?
This bespoke, yes.
Yes.
May I just go back a little bit? Because what I was doing was just going through the two terms of reference documents and giving you some references. Can I just make sure that you've got them? And I'm mindful of the fact that my lord wishes to see the specific documents, so I don't want to skip over them. But can I show you in particular just two passages in both of them? So the 2017, this is in terms of what RAVEC does, and it goes to my point about the will. So this is paragraph 20, and it's the third bullet point. So it is page 171.
Yes.
So that's in terms of what RAVEC does. Executive Committee will evaluate the risk analysis conducted by the RMB in order to, and then you get the who and the what. And the same provision is in the 2021 terms of reference. It's page 178. It's now paragraph 6, and it's now the first bullet point. And again, just to make good the point I've made about the remit, the remit is members of royalty and public figures who are present in England, Wales and Scotland. And again, if I can just show you the 2017 terms of reference, you see the word present on page 168 in para 3. And again, I hasten to add, I'm not saying it's just the words. I'll come back to give you the colour later. But we see present, and then in paragraph...
Sorry, you're going too quickly.
Page 168.
Yes, I'm on 168. I'm in paragraph 3.
Chair is responsible for decisions for individuals who are present
Oh, I see.
in England, Wales and Scotland.
Right, yes.
And then if you go to page 171,
Yes.
you can see there, paragraph 20, first bullet point, exercise the national policy.
Yes.
Again, that same members of royal family and public figures. And then if you go to the next page,
Yes.
172, if an individual who falls within the remit, that's why I've used that word,
So 172,
paragraph 23.
23.
So those are just the passages to make good what I've said about who is in the remit. So it's member of royalty who is present in England, Wales and Scotland. And then we see...
What does that mean?
Which bit, my lord?
Present.
Here. They don't have to live here. They have to be here.
So what if they're not here most of the time? What does it mean, present? Does it mean present all the time, living here, mostly present? What does it mean?
Well, in my submission, it means enough for my purposes, which is it applies when the person is here. So this is...
Whenever the person is
Whenever the person is here. This is again my point about remit, the flying free. This is why the terms of reference don't exclude somebody who is in the appellant's position.
But they didn't, did they? I mean, I understand your point about different, unjustified and inferior, but they didn't exclude him, did they, because he was going to be abroad sometimes, or even to live abroad?
No, but this goes back to paragraph 14 of Richard Mottram's statement. This is the question my lord put to me. Well,
yes, no, I see that, but I'm not sure it does go back to paragraph 14. I mean, paragraph 14, anyway, look, I'm just speaking for myself.
I understand, my
First
lord.
impressions, but it seems to me to address the question of the decision they were taking about the claimant when he stepped back from royal duties.
Yes.
And he says, and I understand why he says, because I've read this thing in its whole, he says that that didn't give him guidance as to how he was to deal with that particular question. I can see why you say, well, it sort of does, or it does, particularly as regards the RMB. I mean, I get the argument. But I think you may be overinterpreting his paragraph 14 if you say that it says he just figuratively threw the terms of reference away and didn't consider them, because the terms of reference are the whole thing. They're the only thing they've got to go by.
Yes.
And he said, but just for this particular question, I didn't have much help from it.
Yes, and I may go back to the grounds of resistance to show you how the respondent has put it, because as I say,
Yes.
they have, as I understand it, put it in far more extreme terms, which is we didn't operate under the terms of reference for you, and it's linked to why they didn't do the RMB, because they say we didn't have to because we weren't operating under that. They obviously go on and have an explanation as well, but one of the defences is this just doesn't apply to you, this whole system just doesn't apply to you because you're not in the cohort, as they've put it. Can I just show you the passages in 2021 now, which start at 177?
Well, just before we do that, Ms. Fatima, can we go back to 2017, paragraph 3, which you were just showing us? Individuals who are present in England, Wales and Scotland.
Yes.
It seems to me, looking at that as written in 2017, nobody was thinking about the possibility that an individual clearly within, we don't like calling it cohort, but clearly within the remit, might go and live abroad. This covers individuals who are present in England, Wales and Scotland, special arrangements for Northern Ireland, and decisions on protective security for any overseas travel from the UK.
Yes.
There's something called the Royal and Ministerial Visits Committee.
Yes.
But there's nothing there about somebody within RABEC protection who goes to live abroad.
Which is why, my lords, I'm going to address you in the closed session about why I'm not saying, just look at this, don't look at anything else. I'm saying, look at this, and then let's look at everything else that goes around it. Because when you have all of that context, this means what it says. It means it's somebody who is present. And so I entirely take your point that looked at in a vacuum, that would not support the interpretation that I'm pressing on you. I'm not asking you to look at it in a vacuum. And I will come back to that word later.
Thank you.
Going back to 2021, and this is just on that remit point, we see it again, the phrase royalty and public figures in paragraph 1. This is page 177. It's in paragraph 2 as well, and then it's in paragraph 6, in the second bullet point. Now, the reason I've made this point in a bit of detail is because the judge criticised our approach. He said that if my construction of the terms of reference was right, then everybody present in England would be entitled to an RMB. That's how he put it, and that is in paragraph 168. And as I submitted before him, The remit point is the answer to why the construction of this document does not mean that everybody can knock on Ravek's door and say, do an RMB for me.
I mean, he may have been going too far. I think the point is the same if he was saying every public figure, because where do you stop with public figures? I mean,
well, this is what
everybody's a public figure in one sense. So,
well,
you know,
my lord, we have evidence.
if that's not true,
That's not. We have evidence.
There are thousands of people who might be.
They might be, but the reason that that isn't a good, I would say, answer to the remit point is we have some explanation of what public figures are in Mr. Hipgrave's statement.
Right, okay.
But that is besides the point, because nobody could dispute that the appellant is a member of royalty and therefore in the remit.
No, nobody disputes that.
The purpose of Ravek's policy objectives, just so that the court has those, are in paragraph 10 of the evaluation criteria document, which we were looking at earlier, but we didn't look at paragraph 10. Could I just invite you to make sure that you've seen that? It's page 175.
Yeah, objectives of the
The
policy.
objectives of the policy, and this goes partly to context for when you're looking at how to interpret not just the documents and how they applied them, but also when we come to good reason. So, responsibility of the Home Office to advise the committee of any relevant developments in these objectives, considered that they will likely to remain stable, must be done openly and transparently so that the committee always has a clear, predetermined policy framework. And this goes back to my Munjaz point. We're not in the territory of merely advisory, because Ravek itself is saying here that what it's trying to do is have clear, predetermined policy frameworks, i.e. something that has to be applied. And it then goes on to explain, again, my lords, critically in my submission, that in practice, and this is after having obtained an RMB assessment, Ravek should then simply have to test the recommendations of the RMB to ensure that they meet the committee's agreed objectives. So again, this isn't something that is a discretionary, voluntary phase that Ravek can choose to do or not do. We get very clearly from this document in particular that the role that this has. So, can I then, if you just give me a moment, I'm seeing whether or not in the question and answers I've covered some of this ground.
Well, sorry, I'm not in front of getting out of place. Can I just invite you to read the earlier part of that paragraph as well, its emphasis on flexibility?
Thank you. My lords, I think that's enough on purpose. Content, I think we've also covered. I've given you the references, I think, in both documents to the significance of the risk analysis done by the RMB. Can I just show you Annex A? Because I don't think we've looked at that. That is Annex A to the 2021 Terms of Reference, and it's at page 185. This addresses the process of Ravek decision-making outside the regular meeting cycle. And I want to show you this just so you can see paragraph 1, which is that, again, the starting point, even for these ad hoc meetings, is to have an RMB risk analysis. Yes.
So in terms of context, I said there were 4 strands. Can I just tell you what they are before lunch? The 4 strands are, first of all, the subject matter of the decision-making process. The second is the composition, role, and expertise of Ravek.
Sorry, say that again.
Composition, role, and expertise of Ravek. And the composition, role, and expertise of the RMB. The third is the nature of the information and analysis that RAVEC gets when it's making decisions about who gets protective security. And the fourth is what we know about RMB risk assessments that have been done for other people and when. So those are the four strands, and if I may, I'll come back to those and then deal with the errors in judgment before going on to good reason. My Lords, I've been given a note, which is that my instructing solicitors have raised a concern that it might be difficult for those in the room to follow the references to the evidence. And so the proposal is that the open, that is to say redacted bundle, be provided to those that ask for it. And I'm told that they can liaise with the respondent solicitors, GLD, to see if that is possible.
Well, is that agreed? I mean, I'm not going to have arguments in open court about things that have not been discussed between the council.
My Lord, there is an open, that is to say,
I understand that the
bundle.
documents are not.
Yes.
I understand that the documents are not confidential within the confidentiality ring, but I would want to know that you have discussed with your.
I've just been given this, my Lord, so I raise it.
Why don't you discuss it over lunch, and if it's agreed, of course, it's agreed. It's fine. But if not agreed, then we'll have to find a way of dealing with it, but not so as to disrupt
Certainly.
the valuable time in this hearing for the argument we're hearing. How are you doing time-wise?
I am behind where I should be.
And how are you going? Maybe you better discuss that with your.
I'm going to discuss that with Sir James and try and persuade him to give me some of his time.
Very good. Well, we will look forward to the outcome and see you all at 2:00. Thank you.